Hi, and thank you so much for joining us for this LinkedIn Live session. I'm really excited to be joined by three incredible privacy experts. But before we get into their insights, I'd like for you to write in the comments, say hi, let us know where you're from. And also in this comment section, you can place any questions that you have. We're going to do our best to get to as many as we can after the presentation. Now, without further ado, I would like to introduce our three speakers who are going to talk about some of the key privacy developments we've seen so far in 2024. I'm really excited today to be joined by Andrea Lisievich, Jonathan Boyette, and Harvey Nuz. So without further ado, please take it away.
Hi, everyone. My name is Andrea Lisievich. I am a privacy professional and consultant myself. And I will take a few minutes going first today to speak about my top picks in privacy developments on the European side, mostly. Obviously, there is a lot going on, not just in European privacy, but globally. I actually publish a weekly newsletter exactly because it's very hard to keep up with all of these things. So it was quite difficult for me to choose only two bigger topics. However, I did choose them, and I chose two that I think are with us to stay. So, without further ado, the first one that I wanted to talk about was consent or pay. And consent or pay or okay, however you might know it, is something that started actually a longer time ago. Quite a few digital newspapers have started to introduce this, let's call it model, where you either accept to be tracked or you either don't get access at all, or you need to pay to access the content. And this happened already from 2018. However, it made it big, so to say, in November last year when Meta decided to introduce it as well. And we, at least in Europe, have been flooded on all of the Meta apps with, let's call them choices to either accept being tracked for advertising purposes or pay a certain amount per year to access Facebook, respectively, Instagram, and so on. And that is when NOIB and the BEUC, which is the European Consumer Protection Association, filed complaints against Meta, and that triggered a bit of a snowball. But the thing is, already in December, there was a court decision actually, no, by the Spanish Data Protection Authority that said a pay or okay cookie banner violates the Spanish law implementing the e-privacy directive, which was surprising for me to see. That was quite early on. And later in March, they have also updated their cookie guidance on this topic. And in April, there have been two contradictory developments. First off, a court in Germany found that Meta's consent or pay is fine by GDPR standards. But on the other hand, a few days after, the EDPB published their own guidance on, I think it's an opinion on consent or pay, which basically casts a lot of doubt that it can be done lawfully because of the main requirement to offer a real choice and conditioning consent by either you give consent or you pay some money is not exactly free. And this has been quite challenged in and of itself. There are voices on both sides of the spectrum saying both that it's lawful and that it's not lawful, and we definitely haven't seen the end of it. On the other hand, that's just under GDPR. But in July, the European Commission announced that it's coordinating an action against Meta under European consumer protection laws. So that has literally just started. And as if that wasn't enough, the Commission, have also started an investigation against Meta, also on consent or pay, under the Digital Markets Act. And they have published preliminary findings in July, and they are quite damning, also because of the invalidity of consent. And here we are in just a few months, in 8, 9 months, there has been a lot of development on this, just in relation to Meta again. And we are seeing this under data protection rules, consumer protection rules, and competition rules. The DMA is largely related to competition law. So three different avenues under which it seems that Consentor Pay is uh, under fire, if not also quite problematic. And just to finish this topic off, the same topic of consent or pay will get its day in court once again, because Noib has challenged the decision by the Hamburg Data Protection Authority, which found that the consent or pay model used by a digital newspaper, Der Spiegel, which actually started off this whole model, um, they found that it was lawful. And Noib, of course, says that they have some problem with that, and that will develop into a litigation. And this has also just started. So we are quite far from seeing the end of this debacle. And I am quite sure that over 90%, I would say close to 99% of the people who have been faced with this choice did not choose to pay money, um, and have chosen, so to say, to give their data. And one of the big problems there, of course, is that even if you pay, you are still your data is still being collected, and it's not clear whether it is used for advertising or not. So I myself have some doubts as to what this choice really is. But anyway, we will hopefully get more clarity on this topic soon enough. And the second topic that I chose was very unsurprisingly the AI Act and all of the developments that we see in Europe around AI regulations. So the EU AI Act has been adopted and published in July. It has come into force on the 1st of August, just a few days ago, but that doesn't mean it's applicable. It's in effect. That happens from February, when the first parts of the AI Act will start to apply, and full application will happen in August 2026. And there is a lot to be done there, and a lot to be discussed on the AI Act. Obviously, I'm not going to go through its characteristics and provisions. That would take quite a long time. However, what I wanted to say was that various data protection authorities and the European Data Protection Board itself have already issued guidelines on the interplay between GDPR and data protection rules in general with the AI Act. And that is because um, especially in LLMs, when we talk about a lot of data necessary to train an algorithm, it's near impossible not to have personal data, which is why these two regulations will most of the times apply together. And on that note, I wanted to mention that the AI Act comes with its own enforcement authorities, which need to be appointed by all of the member states until November this year. And the European Data Protection Board has called for those authorities to be appointed as the data protection authorities that already exist. And this is very likely to happen. And the thing is, we already see that, in effect, the data protection authorities have already started to do enforcement on AI rules, but from the point of view of data protection compliance. And I'm going to mention the ChatGPT task force, which brought together investigations started in quite a few of the member states concerning the lawfulness of ChatGPT's, well, OpenAI's training of the algorithms with various data on the internet. And on that front, I wanted to mention that the AI training and the data used for that training is already quite an important focus area. And I'm sure you guys have already heard that both Meta and X have announced that they dropped their respective plans on using their user data to train the AI algorithms without user consent. So this is really becoming an issue that is noticed quite quickly by the users. Complaints are made immediately. Data protection authorities react immediately, and it's quite significant for me to see that between the moment when someone hits a button and the outcome, meaning don't do this, it's sometimes a week or two, which most of the times until now hasn't really been the case. But interestingly, there are developments beyond just data protection authorities. For example, in July, in Spain, there has been a criminal proceeding initiated against Meta for use of data to train its AI models. And the gist of it is also on compliance with data protection rules. So that will be quite interesting to see what brings about. I don't have a lot of information on it, but still, it's the first time I see a criminal investigation triggered by a non-compliance with data protection rules. And speaking of Meta, they are under regulatory ban to use user data to train AI in Brazil. And they have also been sued for doing this in Argentina. So it's much wider than just the EU. It's not just us. It's slowly flowing to other parts of the world as well. And if that wasn't enough, I will say that Meta is having a pretty difficult year. In addition to everything that we've talked about, they have been fined $220 million in Nigeria for failures regarding consent and sharing of personal data. And in Texas, the Attorney General has announced a 1.4 billion settlement, and I'm sure that Harvey will go into it, so I'm not going to say more. But that concludes the part that I wanted to capture very briefly about European developments. And I would really like to hear your thoughts, Jonathan, on how is enforcement done in the US? We don't have a federal data protection law there. We don't have similar types of data protection authority. What is the FTC doing over there?
That's great, Andrea, and you're right. Honestly, a lot of the things that are going on, the things you've mentioned, it'll be interesting to see how those developments continue. So, talking about the FTC, it's really interesting in that I feel like the FTC has almost become this de facto enforcement body for data privacy, even though, as you mentioned, we really don't have a federal law that governs data privacy. It's actually very interesting. Over the last couple of years, they've provided almost $500 million in fines to various organizations regarding violations of various components of data privacy. Now, the interesting thing is their main focus seems to be around COPA, which is really focused on children's online protection. It's very interesting in that. Also, it seems that really they're focusing a lot on newer technologies, things that really the kids are using, right? And, at least that I see my kids using. So it's interesting. I think as these new technologies continue to emerge and these new applications, they're going to have a lot of concerns and a lot of questions around, is the FTC going to come after me? Is there something going to happen there? The most famous one, I think, recently, at least in the news, is TikTok. TikTok, from what, in the past, the FTC had actually kind of scolded them quite heavily in 2019, saying that they were violating several of the dictates around children's privacy. And they have found that, again, they are still continuing to do so. And in fact, there's an enforcement action pending against TikTok. So that $500 million that I was talking about is probably going to raise significantly when that occurs, especially since the FTC has said that this stretches all the way back to potentially 2020, where really the enforcement action was given in 19. So it'll be fascinating to see how that goes. But what I kind of want to do here now, I want to plead with my fellow auditors and risk professionals. What do we do about this, right? We know that, yes, some of us might not be governed by different laws. We might not be governed by, specific statutes. But the FTC, they're not governed by that, essentially. If they feel that they need to investigate you, especially related to COPA or other regulatory things that are going on, they're just going to, essentially, and an enforcement action can happen. So what that tells me as an auditor is that there's risk. There's something that has to be investigated. There's something that has to go deeper. So again, what I'd like to implore my fellow risk professionals on the line: talk to your leadership. If you're not doing something regarding data privacy, as far as investigating the quality of the controls and procedures in your own organization, then you're potentially doing a disservice to your shareholders or your other stakeholders. So I would strongly recommend that you encourage them with that. Now, of course, the question always comes back, well, if I'm looking at the data privacy controls, then, it's just a check the box exercise, right? No, it shouldn't be. Data privacy is too important for that. It's not the same as standard compliance things that we have. This is people's very private information. This is the soul of who they are as human beings. We shouldn't treat this as just though that it's a commodity. And, for those of us that are doing that, shame on us in a lot of ways, right? Just as Andrea was talking about with the pay the pay approach, that's not really right. You can't consent to do things like that. It's insanity, really. But the main thing I want to implore folks is, again, look into your privacy programs, ensure that they're functioning the way you expect, and not only that, make sure that they are functioning in the way that your leadership wants your data subjects to be treated. And that's really the next piece of how do we do this, right? How do we change this from a check the box exercise to something else? Well, a lot of that is culture. We have to move from compliance to a culture of data protection, and data privacy respect. And the interesting thing is, if you'll notice, a few organizations have done this. A few organizations have seen that data privacy is a concern for their stakeholders, for their end users, and they've come out and they've advertised, hey, we care about your privacy. So not only have they taken that risk and moved it from just being a risk that they have to deal with, they've taken that risk and they've moved it to where it could even be considered a competitive advantage as they continue to expand market share through their advertisement that, yes, we care about your private data. We're not going to share it with everyone in the world. We're going to make sure we secure it effectively. But either way, that's my primary plea to my fellow risk professionals out there. Talk to your leadership. Let them know that this is a risk that exists, even if you're not under a federal privacy law or under even a state privacy law. Make sure you look into that deeper. And actually, speaking of state privacy laws, Harvey, I know you have a lot of interest in our Texas law and have some interest in some of the very unique things that they're doing around enforcement. So how about you tell us a little bit about that?
Sounds good, Jonathan. Thank you. So first of all, I want to say thank you to Recorded Future and mostly to a law firm, Figura, Drinker, Biddle, and Reith, the law firm, for the source of this material. And I may have mispronounced the first name, and I apologize for that. I primarily focus on operationalizing privacy, trying to, or actually achieving, eventually, secure compliance. And what I mean by that is if you take a look at Target in 2013, they were absolutely compliant with PCI DSS, yet they were breached by a third party. So now what has fascinated me about Texas law, other than my living here, of course, and I'm following it, but it seems to me that this has really had an inordinate effect, if you would, internationally. And I think it will from some of the things that we're going to see that has happened from the Texas AG's enforcement actions of the TDPSA. In April, before it came out, in 2024, the AG sent civil investigative demand letters to 4 connected car companies: Kia, GM, Subaru, Mitsubishi. And this is the first known request for documents from connected car companies by a state investigative body as part of an enforcement review, is what I understand. And then in June, the AG provided notice to car and insurance companies regarding the Texas Deceptive Trade Act, regarding their selling data to insurance companies. So that's an example of something that affects us all worldwide. July 1, TDPSA is in effect. And then I also want to I don't have it up here, but there is an excellent survey done called Privacy Nightmare on Wheels. Every car brand reviewed by Mozilla, including Ford, Volkswagen, and Toyota, and they flunked the privacy test. And it is fascinating that cars are probably the provider of least privacy of many of the commodities that we have. So recently, the Texas Attorney General, Ken Paxton, announced the launch of a Texas data privacy and security law enforcement initiative by establishing a new unit focusing on Texas privacy laws. The announcement specifically mentioned not only the TDPSA, but also the Texas Identity Theft Enforcement and Protection Act, the Texas Data Broker Law, the Texas Biometric Identifier Act, also known as the Texas Capture or Use of Biometric Identifier Law, or QB, the Texas Deceptive Trade Practices Act, and the Federal Children's Online Privacy Protection Act, CAPA, and the Federal Health Insurance Portability and Accountability Act, HIPAA. The Texas AG's office did not wait long to demonstrate that the announcement was not an empty threat. And on July 30th, 2024, the AG's office announced that it had reached a $1.4 billion settlement with Meta Platforms related to alleged violations of QB. And Andrea, that's all I'm going to say about that now, but we will definitely get into a discussion in a little bit of some of these things. And going on now, QB, like its more famous progeny, BIPA, the Illinois Biometric Act, obligates entities to give advance notice prior to the collection of a biometric identifier, a retina or iris scan, fingerprint, voice print, or record of hand or face geometry, and obtain consent to the collection and specific uses of the biometric identifiers. It's got a couple of more items that it actually goes into there. I'm not going to cover them now, but want to say that the first notable QB enforcement occurred in February of 22 when the AG's office sued Meta. There, the Texas AG alleged that Meta's photo tagging feature violated QB and the DTPA through its collection of face geometries. The lawsuit followed a California federal court's final approval in 21 of a $650 million class action settlement resolving claims that the same conduct violated BIPA. Then in October 22, the same month that an Illinois state court judge granted final approval of a $100 million settlement of a similar BIPA case against Google, the AG filed another copycat QB action, State of Texas versus Google, LLC. The AG office alleged that Google was not only storing face geometries, but also voice prints. Litigation for that remains ongoing. Andrea, so this is obviously, I would think, of interest to EU privacy practitioners. What are your thoughts on that, please, ma'am?
Right, and that is definitely the case. I guess we don't really see it portrayed quite like, oh, there's a biometric case or something, exactly because in Europe, protection of biometric data is included into the GDPR together with the protection of all other types of personal data, however special or not. And when we do hear about sanctions related to biometrics, it's usually more focused on there has been this fine, this sanction, this ban on processing, and a little bit less about, okay, this is about biometrics. You have to actually read the decision in order to see that. But that doesn't really mean that there's less focus on it. I would say the contrary. So GDPR, as I'm sure you know, doesn't work with the notion of sensitive data. It works with the notion of special categories, biometrics being one. And the rule under GDPR is Unlike with normal personal data, where you, as a rule, can process, but you need to follow some rules, with special categories, as a rule, you can't process. So the rule is prohibition. And only as an exception, you have a few exceptions in Article 9 when you can actually process special categories, in this case, biometrics. So it is actually quite strict, I would say, and it's definitely not something out of the ordinary to see focus and enforcement on protections surrounding these types of data. And there has been a lot of talk in recent months that, for example, AI and AI algorithm training should not include special categories in general, not just biometrics, but obviously biometrics play an important role since they're more common than others, perhaps. So, yeah.
Andrea, with that being the case, how is it that the supervisory authorities in these other in the EU, where obviously these vehicles are still being sold, how have they not jumped in on this at this point, or do you think they're waiting for a specific complaint from a data subject? What are your thoughts there?
It's a great
Well,
question.
to be honest, I am not sure. Going to the car industry, I actually think that this is still not fully understood, not by the public, not by whoever writes about it, and so on. For example, the Mozilla report looks at what the car manufacturers actually state at their privacy policies, not really at what under the hood, so to say. So that there can be quite a distinction between those practices, actually. And that's one point. But also we have quite a few players when we talk about data processing in the or related to the car. We have the car manufacturer, which always processes some data which can be higher or lower. And then it begs the question how much of it is actually strictly necessary to provide the services required. But we have other third parties, and then there are third parties involved in the car. You can have an operating system in the car, you can have third party apps, you can have whatever, but they still provide a service to the person in the car. And then you have third parties that are not in the car, like insurers, like other additional services on top of everything that happens in the car. And the relationships and the roles, when we look at European law, we need to have controllers and processors or joint controllers, is many times very difficult to assign. And based on my own experience with this, many times are not that correctly assigned, and contracts don't reflect reality and so on. So I think also thinking of the EDPB guideline on connected cars from 2020, on which I submitted some comments, even the EDPB didn't fully understand the ecosystem and the complexity. So we don't yet have, to my knowledge, a complaint around these things to actually bring it forward in an official investigation. And I guess it's going to happen. I think it will, and maybe not that long from now.
Thank you.
All right, we have time for a few questions. This first question, Andrea, I think is probably best addressed by you, but anyone else, feel free to chime in. So somebody asks, if I don't pay Meta not to use my details, do they upload my profile to their AI learning algorithm?
Good question, and I should clarify that those are actually two separate issues. But the quick answer is, if you're in Europe, if you don't do anything today, they will not use your data to train their AI algorithm, because they have announced that they're scrapping this after being pressured by the Irish Data Protection Commission, which is the data protection authority in Ireland. So they were going to do this. They've announced that they will. And then they said, we're not going to do this anymore because the EU law is so bad to us, of course. But the other thing with Consentor Pay, that does not concern AI training. That is using your data, and not just your profile, all your interactions, your messages, everything, to tailor advertising to you, to basically decide what ads you see. And there's a whole ecosystem behind that. So two different things.
Thank you. All right. I think, unfortunately, that is all we have time for. But Andrea, Jonathan, Harvey, thank you so much for joining us. And thank you to everyone who's tuning in. We hope to see you again here soon.
Thank you.
Thanks, everyone.